Welcome, truth seekers, to a deep dive into the often bizarre world of self-defense claims. Prepare yourselves, because the evidence we're about to examine is, well, let's just say it's going to make you question everything you thought you knew about justifiable force. We're talking about cases so wild, so unbelievable, they'll make you wonder if the lawyers involved were accidentally transported here from a parallel universe where logic takes a vacation. We'll dissect some notorious cases, analyzing the evidence presented, or, more accurately, the lack of evidence, and the often questionable interpretations that led to surprising verdicts. Get ready, because some of these stories are going to leave you speechless. I mean, you'll probably spit out your coffee when you hear some of these defenses. Let's start with the classic, "I feared for my life" defense. Sounds simple enough, right? But the reality is often far more nuanced. Take, for instance, the case of the aggressive squirrel. Yes, you read that right. A man claimed he was forced to defend himself against a particularly feisty squirrel, resulting in, well, let's just say the squirrel didn't win any awards for its acting skills. The court's response, let's just say it was less than sympathetic. I wonder what planet the judge was on when they delivered that verdict. The problem with self-defense claims, and the reason we're exploring this today, lies in the burden of proof. The defendant must convincingly demonstrate that their actions were necessary to prevent imminent harm. This requires a clear and present danger, not a vague feeling of unease or a preemptive strike based on a perceived threat. The level of force used must also be proportional to the threat. You can't, for instance, shoot someone for stealing your prized petunias. Unless, of course, the petunias were genetically modified to unleash a swarm of killer bees. Then, maybe we have a case, maybe. Many self-defense claims crumble under the weight of contradictory evidence. Witness testimonies often conflict, security footage might contradict the defendant's account, and forensic evidence can completely dismantle a carefully constructed narrative. We'll be looking at specific cases where seemingly airtight alibis were shattered by seemingly insignificant details. A misplaced button, a scuff mark on a shoe, a text message sent at the wrong time. These seemingly minor inconsistencies can unravel even the most elaborate fabrications. One of the most common pitfalls in self-defense cases is the lack of credible witnesses. A lone defendant's account, unsupported by corroborating evidence, often lacks the weight necessary to convince a jury. We'll analyze cases where the absence of witnesses or the presence of biased ones dramatically altered the outcome. Imagine this: a fight breaks out in a crowded bar. Yet, despite numerous patrons, no one steps forward to provide a clear account of what transpired. This lack of independent verification can be devastating to a self-defense claim. Then there's the issue of premeditation. Was the defendant genuinely acting in self-defense, or had they planned the confrontation? We'll examine instances where seemingly spontaneous acts of violence were revealed to be meticulously orchestrated events. These cases often involve a careful examination of the defendant's actions leading up to the incident. Were they armed? Did they seek out the confrontation? Did they have a history of violent behavior? These details, often overlooked, can be crucial in determining the validity of a self-defense claim. Furthermore, the use of excessive force can completely undermine a self-defense plea. Even if a threat existed, using disproportionate force can transform a justifiable act into a criminal offense. We'll explore cases where the defendant's response was clearly excessive, leading to charges of assault or even murder. One example that comes to mind involves a man who used a taser on a shoplifter who was attempting to steal a single candy bar. The irony, of course, is that the cost of the taser far exceeded the value of the stolen candy. Ironic, isn't it? The legal definition of imminent threat is also a crucial aspect we will unpack. It's not enough to feel threatened. The threat must be immediate and credible. We'll delve into cases where the perceived threat was demonstrably unfounded, based on misinterpretations, misunderstandings, or even outright paranoia. For instance, mistaking a garden gnome for a burglar in the dead of night might not be the strongest argument for self-defense. We'll also explore the role of the jury in these cases. Their interpretation of the evidence and their understanding of the law can significantly impact the outcome. We'll analyze how biases, preconceived notions, and even the charisma of the lawyers can influence the jury's decision-making process. It's a complex interplay of facts, law, and human psychology. Self-defense cases are rarely cut and dry. They're complex legal battles filled with conflicting testimonies, ambiguous evidence, and the inherent difficulties of reconstructing events that unfolded in a flash. We will examine the intricacies of the legal process, including the role of expert witnesses, forensic analysis, and the challenges of proving intent. Throughout this exploration, we'll emphasize the importance of clear and compelling evidence. We'll discuss the types of evidence that carry significant weight in court, such as eyewitness accounts, forensic findings, and physical evidence. The absence of such evidence or contradictory evidence often leads to the downfall of self-defense claims. Remember, the legal system is designed to ensure justice. A successful self-defense claim requires more than just a claim. It requires substantial evidence to support it. The cases we'll examine highlight the importance of understanding the legal requirements, the potential pitfalls, and the devastating consequences of a poorly substantiated defense. And finally, we'll leave you with some thought-provoking questions. How can we ensure that self-defense claims are judged fairly and accurately? What measures can be taken to prevent miscarriages of justice? And perhaps most importantly, what can we learn from these often absurd cases to better understand the complexities of self-defense and the crucial role of evidence in determining justice? So buckle up, because this journey into the world of self-defense claims is about to get very interesting. And possibly, just possibly, a little bit ridiculous.